We thank you so much for watching Law School Made Easy at Law School Made Easy 256. We want to discuss today trespass to person, and we want to continue where we stopped, and we're going to discuss false imprisonment. Remember, we agreed and said that under trespass to persons in the law of torts, we have assault, battery, false imprisonment, and malicious prosecution. So after this video, we shall also upload for you the malicious prosecution, and then we shall do the defenses and remedies that are available for trespass to person as a whole. Remember, colleagues, as we go into false imprisonment, remember we also agreed that all the cases are going to be put on voices of the bar. For example, cases of false imprisonment, of course I will mention some of them here, but I am going to do them and they will be on voices of the bar. So if you're looking for cases, we, as of today, I think today is should be 4th or 3rd. We haven't, today should be 3rd. We have not yet uploaded of September, but we are going to upload all the cases. So don't worry, you'll find all the cases on Voices of the Bar. But for now, let's enter into what we call the law of torts, and we are going to discuss in this video what we call the false imprisonment. For starters, what is false imprisonment under the law of torts? To make it even clear and better, false imprisonment, when we are discussing it under tort, I want us to give this some time, and we appreciate it. Number one, false arrest or false imprisonment. This is when an individual has been denied his right to movement. Remember, under Chapter 4 of the Constitution, under Article 23, we have rights of personal liberty. That everybody, you are at liberty at all times to do what you want. Under Chapter 4 of the Constitution of the Republic of Uganda, we have Article 29 that talks about freedom of movement. So we are saying under the law of tort that false imprisonment is when you have been denied your right to exercise your constitutional right, 1, of liberty, 2, of movement. Okay? That is what we mean by false imprisonment. Now, false imprisonment has been guided by elements and characteristics. So allow me go to discuss for you some of the characteristics of false imprisonment. What must you look at and you say, by all means, this is false imprisonment? What must you look at? 1, depriving someone of their personal liberty. If you see that there has been deprivation of somebody's liberty at one time, colleagues, that is what we call false imprisonment. 2, among the characteristics, is compelling a person to remain where he does not wish. If a person has been compelled to remain in the place ordinarily he would not want to be in that particular place, colleagues, that is a sign, a characteristic of false imprisonment. We are saying that restraining need not to be in any cell. People may think restriction is maybe in prisons. It need not to be in any cell or prison. Anywhere. For as long as you see my liberty is being denied, seated on, then you know that what you are seeing or what they have just done is what we call personal liberty or false imprisonment. For false imprisonment as a characteristics to be there need not to be battery. People may come and say he was beaten and then falsely. No, there need not to be battery. Then that is false imprisonment. Then we are saying that the restraint must be total and complete. The restraint must be total and complete. This we are going to discuss when we are discussing the elements. Now, those are some of the characteristics of false imprisonment. We now go to what we call the elements. What must you prove to succeed in the tort of false imprisonment? You must be able to prove elements. There are only 4 elements. Some books write 5, but I will take 4. That you must prove to show that there was false imprisonment. That somebody's liberty of movement, their liberty, their right of movement, their personal liberty to access anything has been denied. Number 1, intentional confinement. Colleagues, you must prove that the defendant intended to imprison you, to confine you in a particular area. You must prove the intentional confinement, that the defendant intended to put you in that position, to restrain you. He intended to lock me in this house. He intended to have me there. You must prove the intention. Of course, when I discuss the cases, like the case of Battle, I think, where a man was driving, for example, a colleague, let's say I'm driving my friend Matalo, Simon. I am in the car with him, and then he tells me I'm stopping there. I just continue, I don't stop. That is confinement. I intended to confine him there because he told me stop there. But I refused and I continued. So that intention, you must prove that the defendant intended to have this person confined in a particular area. Number 2, element number 2, lack of authority or justification. You must prove that your confinement was not as a result of authority. For example, an arrest, a lawful arrest. If police comes and take you to the cells because they have a search warrant, they have an arrest warrant, they arrest you, take you there, that one is allowed. It is lawful arrest. You have committed a crime. So lack of authority. If you find out that you have been confined in an area, in a house, in a dwelling place, in a cell, in a prison, but the people who have confined your liberties of movement did not have an arrest warrant, the arrest was not lawful, then what you went through is what we call false imprisonment. So we are saying lawful, so there must be lack of authority or lack of justification. They move together. So meaning that the arrest must be justified in law. Where it is not justified, they have arrested you and they have subjected you to false imprisonment. Number 3, lack of consent. You must prove consent. Where there was no consent, if I did not allow you to confine me in a particular area, colleagues, what they have done to you is false imprisonment. There must have been consent. Where the plaintiff has not consented to the imprisonment, to the false arrest, to the false imprisonment, then they have wrongly imprisoned that person. So there must be consent of the plaintiff. Where there is no consent, what you have undergone is what we call false imprisonment. Lastly, under the elements, number 4 is total constraint or complete constraint. Colleagues, for you to claim that there was an false imprisonment, there must be total constraint. You must have no way through. You have no way to go. That you have been locked inside. You have no way through. You have nowhere to run to. Total constraint. I will discuss that case of Bad versus Jones on the other channel, Voices of the Bar, where Mr. Bad had come to watch the racing boats. So they crossed the bridge one side, and then he told them, I want to continue to go that side. They told them, you can't continue, use the other way. If you pass there, you can reach where you're going. But he insisted, and he stayed here for almost half an hour. So later, he sued. And the court was of a view that where you have an alternative route, you cannot say there was imprisonment. Because there was an alternative route for you, which ideally you didn't want to use. So you can't claim. So we are saying there must be total constraint for you to be able to claim that there was false imprisonment. So those cases, Bards, Jones, let me see. We have a few cases here. Barton versus Davis. I'll discuss that one. I also discuss Bards versus Jones. It's a leading case, very good case. I also discuss Mearing versus Graham White Aviation. Those 3 cases, I'll discuss them on Voices of the Bar. You'll be able very soon to find those cases. So that is what you have to prove if you want to discuss the tort of false imprisonment. We thank you so much for watching Law School Made Easy at Law School Made Easy 256. Subscribe, share, like our videos. Until next time, thank you.